Good afternoon to all of you. We're going to start. And if I could just get some confirmation that you all can hear me. If somebody can just type in something to me that says that you can hear, that would be great. Can you all hear me? Hello? My equipment is showing that that it's working and that I should be able to be transmitting, that you can hear me. But if I could just receive confirmation from any of the attendees that you can hear me, I will start. Hi, if you could just confirm for me that you can hear me, I'll start, because my equipment shows that you can hear me. I just want to make sure.
The broadcast is now starting. All attendees are in listen-only mode.
Hello, good afternoon. Thank you for joining. I just wanted to make sure that you can hear me, and we'll begin. Well, today's webinar is going to be about complete a short sale seminar step by step. So I wanted to walk you through the short sale process. Let you know that we have successfully closed hundreds and negotiated hundreds of short sale transactions. And, you know, things are, in fact, getting a little bit more predictable, a little bit easier. The banks are fine-tuning their procedures a bit more. Of course, some lenders still remain a little bit more difficult than others, but you know, as time moves on and as we get more and more transactions under our belt, I can during the course of this short sale seminar, let you know about trends that I'm seeing and things that I see going on, and so that we can just basically take it step by step. I am the lead short sale attorney with Adams and Associates, and my name is Lydia Quesada. And I've been doing real estate for about 10 years now. Richard Adams is the founder of the firm, and he's been in practice for over 20 years doing real estate and bankruptcy. We have a short sale team of about, actually right now, 9 processors, and they're all very, very good. They have banking backgrounds, so they come to us with a good deal of experience. And they're a real pleasure to work with, and I'm in charge of all their work, and I supervise all their work, and I help them along, and I'm basically brought in when any legal issue arises, or I also myself audit the files and speak to the lenders. Well, I guess starting in the most basic way, a short sale is when the value of the property is far less than what is owed on the property, such that a traditional sale cannot take place because the seller doesn't have the money to be able to come to the table to pay the lender exactly what they owe for the property. So in essence, short sale is really debt settlement. That's really what it boils down to, is just debt settlement. You're convincing the bank to take fair market value based on a time value of money decision, where they have analyzed the seller's financial situation and see that they're better off taking fair market value now rather than go through an expensive, time-consuming foreclosure process. In a short sale transaction, the lender agrees to discount the loan. And again, financial hardship does remain the benchmark of a short sale transaction. That doesn't mean that we can't be successful in negotiating short sales where there is no hardship, but in those situations, as I'll go into a little bit in more detail later, that's where sellers many times have to bring some sort of cash to the table or sign a promissory note to get out from under the loan. But in the traditional sense, short sale is for those undergoing an economic or financial hardship. Banks are understanding that, in fact, it's very difficult and very expensive for them to navigate through the foreclosure process. In our state, foreclosure does continue to be a judicial process. We do foreclosure defense as well in our office, and we have files that we've been defending in foreclosure for 4 and 5 years. So it takes the lenders a long time to make it through the process, to make it through correctly. So the lenders take that into account when they see that a borrower is experiencing some hardship. They rather just take fair market value than go through a lengthy, time-consuming foreclosure process. In going through and discussing what's going through a lender's mind, they want to know that they're receiving fair market value for the property. They don't want lowball offers. They want to know that they're receiving fair market value. Once we submit a short sale package to the lender will order a BPO or appraisal to make sure that they are in fact being offered fair market value. With that being said, I want to tell you that recently I've seen banks cutting corners and sending out BPO agents that are not really familiar with your area. So for example, if you're in Miami, you may get a BPO agent coming in from West Palm or Boca that perhaps doesn't know your area. And that I've seen has led to very unrealistic values, because once that BPO agent says, no, this property is not worth $210, it's worth $270, it's very difficult to change the bank's mind. So with BPOs, it's really important that the seller's agent be present at the BPO. We get the best results when the seller's agents are proactive and they're at the BPO, or they make contact with the BPO agent, and they let that agent know, look, this is my market analysis, this is why I priced the property at this particular price. And it is what it is. I mean, I'm sure that you know how to do your job, and then the BPO agent's opinion of the property shouldn't be any different than yours. So just want to keep you informed of that. When we're processing the short sale, we do in fact let you know this is the BPO agent. They called. They want access to the property. We ask that you at least make that contact to help us out, because you guys are the ones that help us with evaluations. Our short sale processors are very experienced, but they're not, appraisers, or they're not licensed realtors. So we rely on you to set the price of the property and to be able to back that price up. That being said, if there are situations, of course, where the bank will accept less than fair market value, and that's where there are problems with the property. Like, for example, we've closed transactions where the roof was done without permits. And it was, the agent disclosed it in the listing agreement, and it was marketed that way on MLS. Cash buyer came in and bought the property as is. In that situation, the lender knows why they're receiving so much less in fair market value. They understand the worst thing that can happen is a lender forecloses, takes that property back, and then has to, bring that property to code, or it's a real nightmare. It's very expensive for them. So where there are problems with the property, it's very, very important that it be disclosed so that the lender knows that. And it helps us because, sometimes the BPO agents themselves will not come to the property. They'll just snap some pictures. And the lender, in the negotiator's point of view, they don't know what's going on inside. There could be squatters inside the property. The pool in the backyard could be brown. I mean, those are things that are going to affect the marketability of the property. So if you see that going on, please, we need to bring it to the attention of the lender. In a short sale transaction, obviously the bank wants to net as much as possible. And what I mean by that is that, the bank is paying all the closing costs. If there's a junior lien, they have to make a contribution to the junior lien. If there is a homeowners association dues that are past due, they're going to be making a contribution to that. They're going to be paying the realtor's commissions. They're going to be paying title. They're going to be paying many things, and sure, they do counter offer. Sometimes they refuse to pay title fees. They refuse to pay certain fees, but they're thinking in their mind, what am I going to net? So one of the most important documents to them is the HUD-1 statement that we're submitting with the offer. We submit, the package, the financials with the contract and the HUD-1. And they look very carefully at all the closing costs and what they're going to net out of the transaction. Usually, the first lien holder will not pay a junior lien holder more than $6,000. Therefore, like if you have junior lien holders that have very high balances, or equity lines of credit, you have association dues that are with special assessments, or a lot of delinquent HOA dues. We're going to have to be able to negotiate that, because many times the lenders won't pay everything, all of the past due HOA dues. They'll pay a portion of it, so we're going to have to be able to negotiate the balance. What I have seen lately is that lenders, if it's, for example, HOA dues that are delinquent, they'll pay a lot more where the HOA has filed a claim of lien versus where it hasn't. I've seen lenders pay I've seen them pay upwards of $20,000 to HOAs where in fact the HOA has filed a claim of lien. So just to keep that in mind, sometimes I have a little bit more playroom if there's a claim of lien filed. And as well, first lien holders generally don't pay any tax liens or judgment liens in full, if at all. So we want to know up front, are there any judgment liens? Are there any tax liens? And this is important because it needs to be on the HUD-1 closing statement, and we need to make the lender aware of it, so that when the lender tells us, look, we're not going to pay it, or we're going to pay only a portion of it, we know right away we need to negotiate that. And if you, for example, used our services, I do a lot of that up front. What I do, and I think that makes our services unique, is that and where the realtors use it to the fullest is where they get me involved at or before the listing, and I talk to the sellers. I talk to them about their hardship. I talk to them about their expectations. One of the most challenging thing about representing sellers in a short sale process is managing their expectations. A seller that has assets, that has a good income, it's very unlikely you're going to walk away with, full deficiency waiver. And those are things that they need to be told up front. People do not like surprises. So you'd be surprised how many times when I analyze a person's financials and I tell them, okay, well, this is what I believe is going to happen, they're prepared for it and they understand it. Managing expectations is key, and I ask them up front. I don't take them at their word. For example, what I say is I ask them, do you have one mortgage? If they tell me, yes, I'll say, so you don't have a second mortgage? No, I only have one mortgage. I ask them, do you have an equity line or line of credit? Many of them will say, yes, oh, I do have that. Many people don't understand or don't put two and two together that an equity line or line of credit is a mortgage. And the worst thing that can happen is that we get an approval letter, we pull title, and we find out there's another lien holder we never dealt with. So I ask those follow-up questions. I ask them if they've ever been sued before by, many people, some people have been sued by American Express or different types of credit card companies, have gotten judgments against them. Those judgments become liens against the property that have to be negotiated. I do that research. Depending on the county it's in, I go to a specific county where the seller resides in, and I do a public search. I found out if that person has a tax lien or a judgment lien or anything that I think is going to be affecting the title of the property, so that we can deal with those issues up front. Because I get so many agents that get so frustrated that they put so much work into their transaction, and then when title is pulled, there are issues that have never been dealt with or can't be resolved. So we need to know all of those things up front. Short sales can be as predictable and as smooth as possible. Certain things always come up, but when you analyze it in full up front, a lot of times things end up going a lot smoother. There are basically, two laws that, when you're thinking about short sale, two laws that apply, and they both apply only with primary residences. And that's the HOFA, the Home Affordable Foreclosure Alternative Act, and the MDRA, which is the Mortgage Debt Relief Act. With the HOFA, that was enacted in 2009, and it's going to be around until December 31st of 2012. We don't know if it's going to be extended or not. But HOFA offers borrowers incentives. And what the HOFA program does is that it guarantees, if the loan becomes HOFA certified, the borrower will be guaranteed a deficiency waiver and up to $3,000 relocation fee. So, and for many borrowers, that is very, very important. So, the way it works is that they have to, we have to submit their financial package to the lender, and then, the lender we always try to submit under HOFA, unless, for example, there's already an advanced foreclosure case that, because HOFA is a government-backed program, it's going to add about 60 to 90 days to the processing time. So if we have a foreclosure case that is pretty far advanced, we don't have the luxury of waiting around for HOFA certification. That's why I do a lot of the research up front, and I find out, if the person's in foreclosure or not. If they are, how far along it is, and I kind of help monitor that so that I know exactly how to handle the short sale aspect of it. But the HOFA program can be wonderful for those those loans that become certified. And the great thing about the HOFA program and with short selling a primary residence is that we don't have to wait until there's an offer to submit the package to the lender. We can do it right up front. So as soon as you take that listing, if they start filling out our financial package, that way we can go ahead and submit as soon as the financial package is complete. And if an offer comes in along the way, great, we submit it to the lender. If not, once the loan becomes HOFA certified, the lender will give us 120 days to get an offer. And the good thing about it is that the lender will tell us the price that they're looking for the property or the minimum net. So that's probably a lot of times why you see a pre-approved short sale. It's because it's been HOFA certified. So you know exactly what the lender's looking for. And one of the things with the HOFA program is that the borrower has to go through like an interview process to see if they qualify for a loan modification. They can turn it down. They don't have to take it, but it's just one of the requirements that they have to be evaluated for it. There have been new policy changes to HOFA, and they can kind of continue to change the policies with them, but I see just in practice, what I see a lot of the lenders doing is still applying the 31% of the income benchmark requirement. That, just so you know, that that requirement has been eliminated. A borrower no longer has to show that the mortgage payment exceeded 31% of the income, but in practice I still see lenders going by that, and I tell them all the time that they're wrong, and I send them the policies, but they still keep doing the same thing. So I just want to make you aware of that. Another good thing about the HOFA program is that a lot of times it gives us sometimes a little bit more wiggle room with junior lien holders. We're sometimes able to squeeze a little bit more out of the first lien for the in order to get to the second lien, and it can be a very good and great remedy for the sellers. Right. There are some additional policy clarifications that came in on June 1st, and those are acknowledgement requirements. It kind of makes the sellers feel comfortable when they get an acknowledgement within 10 business days that we've received, that the lender has received their package. They have 45 calendar days to make decision. If they require additional time, they need to give us updates every 15 calendar days. I mean, just in practice, so I don't see a whole lot of lenders really following these guidelines to the T. But nonetheless, HOFA participation is really important to some sellers. So we try to get it where, in fact, we don't have a time crunch with a foreclosure case, or sometimes where HOFA may not work the best. And these are things that I explain to the sellers, is where, let's just say we have HOA dues that are a little bit, that are past due, and I'm going to need a little bit of wiggle room maybe for the seller to bring a little bit of cash to the table or something like that. If that's the case, I can't do that because, in fact, HOFA, forbids the seller bringing any cash whatsoever to the table. Now jumping to the Mortgage Debt Relief Act. That's the other act that applies when you're dealing with the short sale of a primary residence. And that act basically says that if a person sells their homestead property on or before December 31st of 2012, if they sell it in a short sale, that there is no federal income tax liability. And that's key for a lot of people. Many people will tell you, no, I don't want to do a short sale because I don't want to deal with the tax implications. Well, under the Mortgage Debt Relief Act, there is no tax implication as long as they're selling their primary residence on or before December 31st of 2012. Now, there is a caveat to that, being that the loan had to have been given to purchase the property. If the homeowner refinanced the property and took the cash and did something else with it, then the Mortgage Debt Relief Act does not apply. So always be very, very aware of that. Even still, even where, for example, the Mortgage Debt Relief Act doesn't apply because it was a cash-out refinance, or where we're dealing with a property that is something other than a primary residence, meaning an investment property, that doesn't mean that there is going to be a tax liability, because the way it works is that whether the 1099 liability is taxed or not depends, of course, on the interpretation of the Internal Revenue Code. And under the Internal Revenue Code, it's really based on a balance sheet analysis. If the person's liabilities are greater than their assets on a balance sheet, then there is no tax liability. And I really have not had ever cases where I think are a little bit close. I'll ask the sellers just to verify with an accountant. I never had anybody come back and tell me they have a tax liability, just because even where it's close or where there may be a tax liability, the accountants know how to play with the basis of a property and depreciation and things like that in order to make it so that there's no tax liability. So that's something that rarely, if ever, a seller has to contend with. And then, jumping into what is the short sale process in itself. We do process, of course, and negotiate the short sales, and we do all that painstaking work. We're the ones that collect the documents from the sellers. We submit all the packages to the lenders. We do all the follow-up, all the negotiation, and we've made our services very, very easy. Our package is available directly on our website at www.richardadamslaw.com. And under the short sale tab, if you scroll down, you'll find our short sale package, and you'll also find all the lender-specific packages. Some lenders, like for example Chase, wants the financial worksheet on their own specific form. So it's there, so the sellers do not have to do double work. Also, our package, you can actually, the sellers can actually type right into it. They don't have to print it out. It's a fill-in form, and they tend to like that a lot because they can just turn around and email it. Once we receive the package, I review it along with my lead processor, Darlene Gonzalez, within 48 hours before sending it to the lender. I make sure that the hardship is stated correctly, and I make sure that the file makes sense to the lender's investors. I want to see how the financials are worded. I want to see how the hardship letter is worded. I mean, it's not that I sit there and finagle with it, but if somebody is listing in a hardship letter that the reason they want to sell their property is because they don't live in a good school district anymore, they want to move into a better school district, those things are not, from the lender's point of view, that's not going to be considered a hardship. So I go back to the seller, and and invariably there's always something in their life that has changed. I lost my job at one point. I had to deplete my 401k. I got divorced. I mean, many things happen in a person's life that can be worded in a way that it's not going to be off-putting to the lender. As well as sometimes expenses. Sometimes, individuals put certain things in expenses that, could be classified perhaps, truthfully, but in a different way that's not off-putting to the lender. So I help by underwriting all of that. And then the file is assigned to an internal processor. And some agents develop a great relationship with a processor, and they always want their file given to the same processor. We have a lot of that. We have, a lot of agents that work specifically with one processor. We're perfectly fine with that. If you use our services, you will receive, of course, the weekly email updates from the assigned processor letting them know the week's activity on the file. They have to, and they all do. They're very good about that, following up weekly with the lender, sometimes more than once, just depending on what's going on with the file and what stage it's in. And I monitor all that activity because we use an internal system called Short Sale Commander, where I know exactly what's going on with each file at every point of the way. And I'm also available by cell, and that's the way that the most realtors will communicate with me is directly on my cell. They'll call me from their listing appointments. They'll call me and tell me, call my seller. They're waiting for your call. I already spoke to them about you. And that's how I get involved in the process, and it works the best when I get involved from the beginning because I go through everything with them, everything, and I tell them exactly what they can expect. And my cell number, just so that you know, is 786-975-9889. I encourage you, if you use our services, please call me on my cell. Let me know you attended the webinar and you have a short sale listing and you have a seller that has, legal questions. I'm happy to answer them. I do bankruptcy work as well. I've been a bankruptcy lawyer for a long time, personal and corporate law. So that, many sellers will ask, should I do bankruptcy instead? And I know how to answer those questions. Maybe a short seller has tried to do a short sale in the past and they've been, given a cash contribution requirement and said, forget it, I'm going to just let the property go in foreclosure. But now they're having second thoughts. I know how to handle all those questions. Bankruptcy is a great and wonderful remedy, but it's not for everyone. And 9 times out of 10, a seller, for example, is given a much better deal in a short sale from the lender than they will ever get in bankruptcy. So I like to clarify all those things. A lot of times sellers will turn around and say, okay, well, I'm not going to short sell, I'm going to do bankruptcy, and they don't understand the real choice and what's behind the choice that they're making. Once I air it all out, then they understand that they're making the right choice by short selling first. Some people don't even have to do bankruptcy at all. Those individuals who don't have any other debt problems and their only problem is their mortgage, do a short sale. Why are you going to do a bankruptcy? And those individuals that do in fact have other problem debts, sure, get them through the short sale, and then we can clean up the mess. If they had to sign a promissory note, if anything happened, we can clear that up with the bankruptcy and discharge all of that plus all the other debts that they have. So it's really important that they, have access to, to an attorney and be able to ask all those questions, because unfortunately if they go see an attorney that does only bankruptcy, that attorney is going to talk them into the bankruptcy and then they're going to forget about the short sale. And even individuals who have done bankruptcy in the past can benefit tremendously from a short sale. The worst thing that can happen is for somebody to end up with a bankruptcy and a foreclosure on their credit report. And then, and it really does, the bankruptcy in fact hurts, the foreclosure in fact hurts them on their credit report a lot more than the bankruptcy does. So those are things that I'd like to just, drive home to people so that they understand. There's so much misinformation out there that they really understand what's in their best interest. Now, getting to our fees, because a lot of people, when they hear, I'm going to have an attorney work on your shorts, they'll immediately think they're going to have to come out of pocket, several $1,000s, or they're going to, somehow end up in bad shape. But it's not the case. I mean, right in our short sale package is our engagement agreement. We do not charge the seller anything. We get our fee directly from the lender, fully disclosed on the HUD. No backroom fees, nothing like that. And our engagement agreement is clear that we charge the lender $3,500. It's a negotiated fee. Some lenders will pay it all. Some lenders chop it down. It is what it is, and that's what we accept. And we don't look to the seller or the agent or anybody else to make up that fee. That's why we ask that when you allow us to process your short sale transaction, that you also use our title company, Title Partners of Florida, and the short sale addendum that's part of the package actually has Title Partners of Florida as a title agency, because sometimes we're able to make up some fees on the title side, of course, fully disclosed and approved by the lender. So it's always really important to the sellers that they understand they're not going to be responsible to pay, and their realtor's commission is not going to be at all affected. And our fee comes directly from the lender. It's great for the sellers because they get the best of both worlds. They get to be represented by an attorney and ask me all the questions that they want, and they're not responsible for any fee. When we get into the short sale process itself and we're talking about the short sale transaction, I like to kind of break it up into different parts. And the parts that kind of make the most sense to me when I'm, thinking about short sales, I'm thinking about three things. I'm thinking about, knowing, the seller, knowing the property, and then preparing the buyer. And knowing the seller is a key thing, because that is, in this situation, it's our mutual client. It's your client as your seller, and my client as, I'm entering into a legal relationship with them. And one of the most challenging aspects of a short sale is managing that person's expectations, so they understand exactly what they're getting into, what the benefits are, what the pitfalls may be, so they can make an informed decision up front. Because, as the realtor, your fee is contingent upon, of course, the transaction closing. You don't make your commission unless there's a closing. I don't make my fee either unless there's a closing. So I want to know up front, is the seller going to cooperate? I get so many agents that get so frustrated. They go out there and they get these listings, and it's hard. It's hard to be an agent these days, and it's hard to get the work. And they do all this work to get these listings, and then they get a contract on the property. And then they get to the point where they need their seller to turn over financials. And you'd be surprised how many sellers will say, I'm not going to give my bank statements. I'm not going to give my tax returns. Well, I mean, this is debt settlement at the end of the day. That's what short sale is. And if the lender is going to accept far less than what they're owed and is going to forgive the difference, they have the right to see the financials and know that their borrower does not have the ability to pay. And that's crucial. And I tell the sellers all the time, be prepared to have to update your financials. There's on every step of the way, when we submit the package, after the BPO arrives, once it goes for initial review, once it's sent to management for their review and approval, and once it's sent to the investor for their final review and approval, you're talking about a period of 2 to 3, 4 months, sometimes maybe even a little bit more. And during that time, during every step of the way, the financials have to be updated. The lender has to know up until the time that it's sent to the investor, who is the one who actually owns the paper, owns the debt, that seller's situation hasn't changed, that they still do not have the ability to pay. So, I'd like to tell them, please be prepared. Keep your bank statements aside. Keep your, pay stubs to one side. So when I ask you for them, they're handy and you can just give them to us. I also ask them about assets. I want to know, do they have any other properties that have equity? Do they have any stock portfolios, money market accounts? Do they have things like that? CDs, savings accounts? If they do, that has to be disclosed in the financial affidavit. I want to know what's in there so that I can prepare them for what they may receive, the counteroffer they may receive from the lender. And I like to, for example, if it's a 401k or an annuity or a pension and something like that, those things are not taken against the seller because those are tax-exempt assets, and those assets are protected from creditors. And the banks know that even if they got, even if they went through foreclosure and sued for a deficiency, even if there's $500,000 sitting in a 401k account, they're never going to be able to touch it. So they don't really hold those things against the seller. So I like to also, just ask the sellers what kind of assets they hold. Again, I want to know, and I need to know, how many mortgage liens are against the property. Very crucial, because I need to be able to negotiate with the junior liens as well. Judgment liens. Have they been sued at all? Have they done any repairs or improvements without permits? Foreclosure. We can't take their word for it. I ask them, when was the last time they made their mortgage payment? If they tell me 2 years ago and they tell me there's no foreclosure case pending, I'm going to be very suspect. I'm going to, go to the county docketing systems, and I'm going to find out if there in fact is a foreclosure case pending, and if there is, exactly where in the process it is. HOA dues, we need to know how far behind they are, because when I submit the HUD-1 closing statement to the lender, draft closing statement, they need to see exactly how much of their sales price, how much their net is going to be affected by HOA dues. So, lenders like Bank of America, for example, if we go back to them, if once we get an estoppel, the HOA dues are more, they consider it a deal change, and then it's going to add on another 4 to 6 weeks to the processing time. So we need to be as accurate as possible. I want to see, copies of the last demand letter. I want to see something in writing where I can, do the math and somewhat figure out exactly where the HOA dues are. And also, if the HOA has already sued, then obviously there's an attorney involved. That becomes important, because lenders do not pay HOA attorney's fees. They don't pay late fees. They consider all those things junk fees. So I know right off the bat I'm going to have to start negotiating well before there's an approval, just to know that I'm going to have a HOA that's going to be on board. Back taxes to the IRS, I'm seeing that a lot now. I'm seeing a lot of federal tax liens against properties, so I search for that. And code violations are also pretty prevalent. The next aspect is knowing the buyer. I see, more and more short sales are out there, more buyers understand that it does take a bit of a time in order to make it through the short sale process, and so they need to mostly understand that they need to be patient. And they need to, if it's cash buyer, we're going to need definitely right away the proof of funds. The lenders are asking for it. The lenders I see also, if there's, there should be a deposit. Lenders do not like it if they see a contract with where the buyer doesn't have any cash already in escrow. And they ask for the escrow letters as proof that the buyer has something on the line. If it's a finance transaction, we don't want these buyers waiting until the very last minute to apply for their financing or to get their financing going. Because what I see happening with the lenders is that they're giving one extension and one extension only to close. And if we're asking them for another extension, some are saying declining the file and making us resubmit, or they're requiring a per diem, and it could be very, very expensive. So just please know that you got to stay on the buyers as well to make sure they're doing what they need to do in order to move the deal toward closing. Another big one that I see, for example, where there's a homeowners association involved, I see the buyers waiting too long to apply to the HOAs. I mean, there are some HOAs that it takes like 8 weeks to get an approval from, because they do an exhaustive search and background check, credit check, everything. And the lender's not going to wait for that. So we need to, have buyers that understand this, and we need to stay on top of it. We have to work as a team. Everybody has to be working toward the same goal, and we can't be waiting until the last minute, because that's when deals fall apart, people get upset, and we try to be able to prevent that as much as possible. And then knowing the property, of course, is where I rely on you guys as the realtors, because that's your area of expertise. And when you tell me, Lydia, this property is worth this amount, then I believe you. I believe you. I know you're doing your work and you're doing it right. And again, properties need to be listed for their fair market value. If it's a low ball, we need to have something that there's be problems with the property, something that I can show the lender why they're receiving less than fair market value. You know, that's really critical. That's where I rely on you. I rely on you as well when I challenge valuation. If, for example, we get a bad BPO, I rely on you as the agent to tell me, to give me the backup that I need in order to show the lender why their BPO is wrong. And you guys are really good at that. So, you know, if it's an FHA loan, the lender will give us a second BPO. If it's not, then the lender is going to make us challenge valuation, or in the worst of scenarios, we have to wait 90 days until their BPO expires, because these lenders' BPOs, they expire every 90 days, and they're being very mindful of those 90 days. So going back to the situation where we had to actually, you know, get the lender to extend the closing date, let's say, for example, because we haven't, you know, received approval from the second lien, or the buyer's financing is taking too long, or anything like that. If you know, if the BPO falls outside of 90 days, the lender will order another one. So that's gonna delay closing. That's gonna delay the final review and approval. So we need to be really mindful of making, you know, sure that we can try to close within the parameters of the first approval letter, because anytime we ask for an extension, we're running the risk that the lender's BPO has expired, they need to order another one, and that the value of the property could have changed. I mean, I'm here in Miami-Dade County. I don't know exactly where you guys are from, but there are some pockets of Miami-Dade County where the properties values are rising, like Miami Beach, like Doral. And there's some areas like that that are going up. So I've had in short sale scenarios where the lender's BPO has expired, they've ordered another one, and then guess what? There's a counter offer. They tell me, no, the sales price is no longer $280, now it's $310, because the property values in those areas are rising. So we have to be really careful. That's why I don't like to ask for extensions. I like to be ready to close within the parameters of the approval letter. Getting to foreclosures, it's really important, like at the time, like I said before, at the time of listing, that we know exactly where we are in the foreclosure process. And, you know, Miami-Dade's docketing system, for example, all of them really will, you know, give you an exact status of the foreclosure case, and they're pretty good about, you know, staying up to date. Broward's the only one that's a little bit more tricky, because in order to be able to really see and know what's going on with the docket, you have to buy units. So it's a paid service. But you know, if you're in Broward County and I'm processing your short sale, you don't have to worry about that. I'll look into it and I'll monitor the case to make sure what's going on. But we don't want to take a case, for example, where the property already has a sale date. Now, unfortunately, a lot of times these sellers, they will in fact wait until it's too late. You know, they receive bad advice from people that tells them, oh no, you know, why are you going to short sell your property? The bank's going to take 2 years to take it from you. You know, why don't you just stay there, and then, you know, when it's the end of the line, then you list it. I mean, that's just that's not a safe game, because once there is a sale date established, it's difficult to get that sale date moved. In Miami-Dade County, for example, where we still have an emergency calendar, I mean, I can still go in as late as, you know, the day of the sale and ask the foreclosure judge to move the sale. And depending on what's going on in the short sale, I mean, many times I'm successful at it. But for example, in Broward County, it's very, very hard. It takes at least 10 court days to get before the judge, and in many cases a lot more than that. It's very difficult to get before the judge in Broward County, and it's very hard to get the sale date moved. And then invariably what happens, it's all a big scramble at the end of the line, and then it costs the sellers a lot more money, because at that point then you need legal representation to go in and move a sale date. So I really strongly advise that these sellers do not wait until the last minute to try to list their property and sell on a short sale. It puts everybody under the gun, and it's not fair. That being said, I want to know basically if any of you have any questions or anything like that that you'd like to share. I mean, I can just read out the question and answer it, and you try to help you out. I encourage you, please, to visit our website to learn a little bit more about us, and to call me if you have any questions or concerns. I work with many, many realtors, and you guys out there, you're learning. You're really knowledgeable, and you're really a pleasure to work with. And we get great results where I've established that kind of relationship with the agents where they get me involved from the beginning, and and they let me, in fact, help them manage all those expectations and do the research, make sure that we have a good and viable short sale. I have some agents that don't even take a short sale unless I fully analyze it. So with that said, I hope that you would, please, learn a little, want to learn a little bit about us, that you would do so. And if you have any questions, please at this time, go ahead and type them in, and I'll be more than happy to answer.
Okay, Maria Monard asked a question. If the seller has to answer a summons, do you advise them and or answer it for them? If so, is that included in the package or is there a fee?
That's actually a good question. And foreclosure defense is a separate retainer fee, and that is, it falls outside of the short sale processing. But with that being said, because we're all aiming toward the same goal of having this transaction closed, the last thing I want is for a seller to get defaulted and lose their property in foreclosure during the time that we're trying to help them. So, they can do one of two things. They can either hire me to do the foreclosure defense, or if they are really one of those individuals who tells me, flat out, I don't have, Lydia, I can't hire you or anybody for that matter to defend my foreclosure because I don't have the money, I will spoon feed them a response, and I will make sure that something gets filed that will in fact put the foreclosure case at bay. So the last thing I want is a seller writing a letter to the court like many of them do. They tell me, oh yeah, I already answered the foreclosure case. Here, this is what I wrote. And it says, Dear Judge, I haven't paid my mortgage in 2 years because I lost my job, then my wife got ill, then this and that happened. And that's just, at that point you basically made the bank's case for them, and you've established that the lender in fact can foreclose. It's under the terms of the contract, with the lender. If you don't pay your mortgage, they take your home. So as badly as a judge may feel for you, there's nothing they can do, and the process will move faster. Okay, Stuart K. asks, in a short sale, does insolvency allow for no tax implications for a second home or investment property? In fact, it does. If the person is insolvent under the IRS code, there is no tax liability for any sort of investment or second home. And Christy asks, I might have missed this already, but did you mention if all people are forgiven the debt? Many, many people are. It really just depends on the financials, and that's where I like to analyze them. I mean, if I look at financials and I see somebody makes over $100,000 a year and has, a lot of positive cash flow, I'm not going to tell that person, I'm going to, get you completely forgiven. That's not very realistic. And you'll be surprised how many of those people will say, great, I'll pay, I'll, negotiate it for me as low as you can, and then it makes sense for me, I'm going to do it. Just so you know, I had this one individual that he was a plastic surgeon out of Pennsylvania, and had an investment property here where the lender was taking almost a $400,000 haircut. He had tremendous positive cash flow, almost $1 million sitting in the bank, and all he had to pay was a $20,000 cash contribution at closing. He was ecstatic. But had I told him from the beginning, you're going to get away with no deficiency, and you're going to be completely forgiven, he probably would have been a little bit ticked off. So, when I look at the financials and I see that somebody does have a hardship, doesn't have much positive cash flow, thousands of dollars in the bank, yeah, I mean, with pretty good certainty I can tell him you're going to be okay. Okay, Richard has asked, Richard Brown, will you outline the necessary steps from the buyer's agent's perspective? Well, from the buyer's agent, if I was representing a buyer in a short sale, I would want to know little things like how many loans are there against the property, because it's important. I mean, a buyer, if you're going to put a contract on a piece of property, they need to kind of know, more or less expect when they're going to be able to, get this approved. I would want to know a little bit about how many liens are, is a short sale mitigator going to have to negotiate. 1, 2, 3. Where are the HOA dues? Are they, really past due? Are there questions like, are there judgment liens? Are there things that are probably going to be an impediment here? Because, a lot of times what happens, Richard, is that the buyers have to pick up the tab. So if you're working with a buyer that says, look, I'm going to put an offer on this property and it's $320, but I really am not going to pay any more for it. And there's an HOA lien on the property, or the HOA has already put the property in foreclosure, or there's some judgment liens, or there's like 2 mortgages where the second mortgage is quite high, I can almost guarantee that there's going to be a counteroffer to the buyer to bring up and make up the difference. So those things are really important. Also, who is negotiating the short sale? Is it going to be the seller themselves, or is it going to be, a title company, or is it going to be an attorney's office? I mean, I have some buyers, realtors who say, look, I will put an offer on this property, but for example, Adams and Associates has to negotiate the short sale. And many times if it's a seller that's really willing and able to and wants to sell their house, they'll agree to that because they want to know they have a good buyer who's going to be informed and who's not going to walk away from the transaction. And those are really important things because the more mess there is with a property, the more loans and liens and things like that, the more we can expect the buyer to have to come out of pocket to pay additional money for the property. All right, Stuart asked, how difficult can an HOA or condo association make a short sale when they are owed money? How do they manage their financial expectations? Well, they can make it pretty difficult because it's debt settlement when it comes to them as well. They have to agree to take less money for a piece of property. I mean, what I usually do, how do I manage their expectations, and what I do is that, let's just say, for example, the HOA is due, I don't know, let's just give a round number, $10,000. I tell them, if the mortgage lender forecloses on this piece of property, you're going to get the greater of 12 months association dues or 1% of the mortgage balance. You're not going to get any more. So in this transaction, let's just say, the lender is offering you $6,000 or $7,000. Let's just say the buyer is willing to come up a little bit. I tell them this is a lot more than what you're going to get if the lender forecloses. So making a time value of money decision for your association, you need to just take this and run with it. It's more than you're going to get if a lender forecloses, plus you're going to get a fresh buyer in there that's going to start to make their monthly dues on time. And that's much better than, number one, for the association to file a claim of lien costs money. Even if they've already done so, to foreclose, it's a judicial process. It's going to cost them a lot of money and time. And what's going to happen? Yeah, sure, they're going to own the property at the end of the day if they foreclose, but after how much time and how much money out of pocket? And then it's still subject to the first lien that has to foreclose them. So, and most of the time associations, they understand that and they're willing to say, okay, fine, I understand nobody likes to take a haircut, nobody likes to take much less money than they're owed, but when you put it down to them in paper and say, okay, well, this is what you're going to get when the lender forecloses versus this is what you're getting now plus a fresh buyer who's going to pay their monthly dues, they cave. Rarely do they not cave. Usually where they don't cave is when there's a lot of bad blood between an association and an owner. Some of these condo commandos, they really hate each other. And sometimes they hold on for make a really bad business decision. But most of the time, they understand numbers. Maria Monard says, for Orlando sellers, consultations are by phone, or do you have an office in Orlando? They're by phone. Even like the majority of our consultations are in fact by phone. I have found by doing this over the years that that's how people feel comfortable. Some people will tell me, some sellers will tell me, can you call me tonight at 7 o'clock when I get home from work, and and I'm comfortable and I can sit down and talk about my situation. Most people want to do everything electronically and over the phone, and that's how I handle, even in Miami most of the time, is by phone. Christy, is there different rules for a second slash and home investment property and not a primary residence requesting a short sale? The biggest difference is that obviously with a investment property, there is no HOFA, so there is in fact no guaranteed waiver of deficiency. But other than that, it's debt settlement, and it really boils down to the person's financials. I've had many situations with investment properties where there has been a waiver of deficiency, and it really just boils down to what the financials look like. So other than the fact that HOFA is off the table, it pretty much works the same way. And now that we're on this point, one thing I wanted to say is that lenders pull credit reports, especially Bank of America. So if I always ask the sellers, have you made any major purchases? If they tell me, I just purchased another home, we need to know that, because the lenders will pull credit and they'll know, is this a strategic default? Are you can't pay us now because you bought another home. So I need to know, have they bought another home? I also had this one guy that I was negotiating a short sale. I asked him if he made any major purchases. He said no. And when the lender pulled his credit report, a loan from Porsche Financial came up for $120,000. I'll tell you that it was very hard work, but in many months I didn't want to give up on it, and finally we actually just closed it last week, and very favorably, but it really ticked off the lender. They felt like we were hiding something from them. So if a major purchase has been made, I need to know up front, because if it has been made, then the lender probably is not going to waive deficiency and may require a cash contribution. Maria Menard asked, for my Spanish-speaking sellers, do you have bilingual officers? Right, yes, and I'm fully fluent in Spanish, so I'm the one that speaks to them in Spanish, and so does everybody else. All of the negotiators, except 2 of them, are Spanish speakers. So if you have a Spanish-speaking seller, I'll assign them to a Spanish-speaking short sale processor, and they communicate. Even the emails are in Spanish. So even if there is absolutely no English ability, we have the ability to help them out. Any more questions? Okay, Maria, great question. She asked, do we have to submit both pay stubs and bank statements or just the ones for the mortgage holder? It's only for the one that signed the note. You know, obviously if you have a husband and wife, they'll both be on the mortgage because that's what allows, that's the document that allows the lender to foreclose. That's what carries the security. The note is what says, I promise to pay. And it's only the person that promises to pay that is we're going to need financials from. So, I mean, in this situation, Maria, you know, if you have a husband and wife, and maybe the husband makes over $100,000 a year, and you know, the wife is now a stay-at-home mom, or she has a part-time job because she's, you know, helping to raise the family. It's only her financials that I'm going to need. And so, in that case, while the household income is high, the wife is the only one whose financials the bank can consider, and that's the only one they have recourse against. So in that case, there is a hardship. She only works part-time, doesn't make much income. The note holder is the only one that the person who signed the note is the only one from whom we need financials. And I review all of that. I mean, I asked the sellers, you know, who signed the note, and if they don't know, I'll ask them for a copy of the mortgage statement. A lot of times, many times, if it comes only in one of their names, then I know that only one of them is liable, only the one in whose name the mortgage, actually the statement comes. But if not, I'll ask the lender, or I'll have them give me, you know, get me a copy of the closing documents so that I can see the note. And with that, Maria, of course, if they both sign the note, then yes, the financials of both would have to be considered. Just like, for example, we've had situations where it's been, you know, brother and sister, you know, and now the sister is living on the property and wants to do a short sale. Well, we need the brother's information as well, because everybody who signed the note, their financials have to be reviewed by the lender. That's right, Maria. Only the note holder is required to present documentation. Yeah, in that case, then all you would do is just, if they're both on title, obviously, then both would have to sign the conveyance documents, the contract, but it's only the financials of the person who signed the note that is going to be considered by the lender. All right. Thank you so much for joining us, and please, I encourage you to, you know, look at our website, to call me if you have any questions. Again, my cell is 786-975-9889. If you have any questions at all, just tell me that you had joined our webinar. Thank you so much for your time.